Good
Okay.
morning, everyone, or good afternoon, depending on where you're sitting. Welcome to today's webinar on a little update on the DOL exemption procedures. Thanks for coming. My name is Steve Wilkes. I'm the Chief Legal Officer and a partner at the Wagner Law Group. My esteemed colleague, Michael Schloss of Counsel in our Washington, D.C. office, and for many years served in senior leadership roles in the Department of Labor before in EBSA actually before joining us, and I guess also in the solicitor's office for a time, if I remember correctly, Michael, and has been has joined us recently, but very esteemed career within the department. So hi everyone, welcome. We're going to talk about the DOL exemption procedures today, the new regulation that just came out. And I can tell from looking at the registration list, I've recognized a few names out there. I know some of you, most of you, I think, have some experience and some, knowledge of prohibited transactions and exemptions and the procedure. There may be some of you who are more experienced than others, so we'll try to tee this up as follows. Let me just give you a little overview of what we're going to try to accomplish, and then I'm going to turn it over to Michael to kind of walk us through the conversation, and you'll quickly see that he all those years in the department, he knows so much more than I do. I never cease to learn. I'm always learning something new from talking with him, so I'm really glad that he'll be able to lead us all through this. We at the firm at any point in time, I lead our fiduciary practice as well as our fiduciary practice group, as well as our independent fiduciary practice group. At any point in time, we have a few exemptions going, and we're working on some independent fiduciary projects. So we have some perspective, and obviously we need to be cognizant and aware of these rule changes that are coming along. So we're going to talk today about, just kind of a little, I'm going to set the table first, a little overview on the ERISA background and exemptions, and then we'll walk through in a little more detail on some of the nuances and requirements of the new rules. But first, just by way of background, just so you can all remember, we have this new prohibited transaction regulation that became that was just published back in January. But the history here goes back for a long time. Back in 1975, we had ERISA Procedure 75-1, which is also issued as Revenue Procedure 7526, by the IRS, and that focused on exemption procedures. And then there were some updates, followed the reorganization plan in 1980. And the department, has issued some additional guidance over time. And in 1990, the department published a final regulation on the exemption process that superseded all its previous guidance. 1995, they published exemption procedures, which I was remembered the other day, Michael. I had kind of forgotten about it, but our colleague Susan Reese in our DC office was one of the authors or contact people on that publication back
Mhm.
in 95. Then updated again in 2011, and now here we are in the year 2024. There was a proposal and then a final regulation in January of this year. And what it's all about is the process for applying for an individually granted or a class exemption with some nuances and changes. And I think for the most part, they are incorporating and just codifying, if you will, or putting into regulatory format terms and conditions, needs, wants, desires that they've always had, but they were kind of informal, and you kind of learned about them as you went through the process of applying for an exemption. So now they've kind of put it in writing to make it more clear. They raised a lot of issues. I was reviewing some comment letters the other day, and a lot of the things that we heard from the community revolved around concerns that this regulation seems to be restrictive. It's going to cut back on the requests, on the ability to get an exemption, or it'll be a hindrance for people to even think about applying for one. Some of the definitions on qualified appraiser and qualified independent fiduciary seem to be a bit restrictive. There were some general questions on whether the department had overstepped its bounds, all kinds of things. So I think the department gave careful consideration to all of these things. So, the process, anonymity, the ability to have conversations with the department. I think they tried to take good account of all these concerns, and Michael's going to highlight them as we go through. And we are where we are. And I think one of my personal observations really is that we have the regulation, and notwithstanding all the press and the buzz and the with the other webinars and client alerts and things, everyone has their view. We have what we have. It is what it is. And if you really look at the spirit and what is supposedly the intent of the department in these regulations, and really understand all the details, all the needs and wants of the department to grant an exemption, the terms and conditions. If you do your homework up front, you really facilitate the likelihood of your application going through in a positive way. And so I think it's really important to really understand these details and just do all your homework and to really work hard to make the right things kind of happen. So
okay.
I think that Michael, I'll turn this over to you, and if you don't mind, I'll pop in with some questions and observations
Sure.
as you go ahead.
Sure, and I'll just make my own initial observation as well, that the new rules are quite detailed, and I think, Steve, you're absolutely right. Part of the idea here was to sort of lift the veil of a informality so that people understood going in what would be required. It would be less of a black box. It would be sort of easier for people to know ahead of time what they needed to gather, what the conditions were going to be. And I think that despite some grumbling that maybe this was adding a little too much detail and making it a little more onerous, the fact was the years leading up to the issuance this last year, the number of exemption requests had already been going down. So that, it's not the new procedures that are related to any drop in the number of exemption requests. And it might be that these procedures actually do succeed in sort of opening the door back to what had traditionally been a fairly robust exemption process and exemption industry. I do note last year there were 21 exemption requests put in, which was incredibly high, since in the 4 years prior to that, it was less than 21.
21 granted.
21 granted. But if you look at the 21 granted, almost half of them related to Blue Cross investments in a failed investment where they were trying to make up for the losses that the plans had covered. A lot of the remainders related to companies that had affiliates convicted of crimes, either foreign or domestic or both, that were seeking QPAM exemption.
Right.
And so I am hopeful that with the department's clarifications that the exemption process will be more attractive to those interested in seeking the relief that it can offer.
It's arguable, and there are, I don't know the exact number off the top of my head, but there are numerous statutory exemptions, and they've increased over the years.
Mm-hmm.
And you were primarily involved. You were very engaged with cross trading, for example.
Yes.
That because you were one of the key players behind that one. So we have a good number of statutory exemptions. We have a good number of class exemptions. Most recently, 2020-02, which is kind of the exemption du jour in the investment advice world, and we have the ex-pro process, which is still out there. So arguably, the groundwork has been laid for people can rely on certain things, and the path forward has been cleared to some extent. But the counter argument to that is that this has become very difficult, and the department doesn't want to grant them, and it's inappropriate not to grant an exemption for a good deal that'll benefit participants. So we'll see where this all lands. Our expectation and our position is that these are the rules, play by the rules, play hard, and win.
Yep, there you go. So I think that's the hope, I think, is to make it easier for the department and easier for everybody else. Whether it will increase the number, that will be seen. Can't decrease it by that much is my point. But we'll see. But the ERISA background, I'm going to go through the background hopefully fairly quickly, so that just people with less than a robust experience with ERISA sort of know where we're coming from. There are two aspects of ERISA, Title I and Title II. Title I is the fiduciary provisions. That's administered by the Department of Labor. Title II deals with the tax. That's dealt with the Internal Revenue Service and Treasury. They generally have identical provisions relating to what is a prohibited transaction. And the exemption process that we're talking about is exemptions from the prohibited transaction provisions for ERISA 406 and 407, for example. So that's very important as to who has authority. Department of Labor right now has the authority on its own to grant exemptions as a result of the reorganization that Steve mentioned. Exemption requests and final exemptions are made public by the department, and you can rely on a class or statutory exemption without notifying the department. So that sort of sets the rules here. Let's go to the next slide.
Just minor side point. I think on 2020-02, of course, just for those of you experts in the audience, of course, if you're correct, if you're relying on 2020-02 and you made a mistake and there's a correction, you have to notify the DOL.
Okay. Yeah, and in 2020-02, I believe, is in play with the fiduciary reg now too. So that is an evolving world, which we are, of course, paying close attention to. Let's go to the next slide, which just discusses what plans are covered. Title I plans like welfare plans, plans covered solely by Title II, such as IRAs, and then plans covered by both Title I and II, such as pensions and individual account plans are covered. There are exceptions. If you have an exception, you have a question about exception, like a government plan or a church plan, call us and we can talk about it. Next slide. So ERISA, again, prohibits fiduciaries from engaging in plans, from engaging in certain types of transactions involving parties in interest. Those parties in interest are called disqualified persons under Title II, under the tax provisions. There's basically two types of prohibited transactions, again, to be very overly generalizing the matter. One are the types of transactions that occur between a plan and a party in interest, and the other ones are situations involving fiduciary self-dealing, conflicts of interest, things like kickbacks and the like. Let's go to the next one. Who is a fiduciary? The fiduciary is the person at the center of it all, that one who's responsible for making decisions for a plan. It's important to know who is the fiduciary for any plan, because that is the person or entity that's going to be held responsible for knowing whether or not a transaction is or is not a prohibited transaction under Title I. So for just quickly, a fiduciary sort of fills could be one of three categories. One is an entity or individual who has discretion or control over a plan's assets. Number two is an entity that renders investment advice for a fee or other compensation. I would note, if you're paying any type of attention to ERISA right now, the Department of Labor has proposed new regulations relating to who is an investment advisor for a fee. Those regulations, after hearings and thousands of comment letters and petitions, have now been sent over by the DOL to the Office of Management and Budget at the White House for approval. Assuming it is approved, we might see it as soon as May. So pay attention to that. If you're an investment advisor for a fee, that's a new rule. And then if you are an entity that has any discretionary control over the administration of a plan, you are a fiduciary as well. Let's go to the next one. Who is a party in interest or disqualified person? Again, for prohibited transaction purposes, it's important to know when a plan is engaged in a transaction involving one of these entities, because that will be a trigger to make a transaction a prohibited transaction. And so those include transactions with service providers, the employer or the union sponsoring the plan, related entities or individuals, employees, partners, and of course, plan fiduciaries themselves are considered a disqualified persons or parties in interest under Title I of ERISA. Going to the next slide, the common types of transaction requests received by DOL, and this is over the years. It's evolving, but for exemption requests where, if you're looking to sell property to a plan, usually, in order to fund a contribution or the like, the purchase of property by a plan from a party in interest, loans by a plan to a party in interest, and the issuance of stock rights. And that usually applies to where a sponsor wants to issue warrants to like all its shareholders, and a plan might be a shareholder. So making sure that you do that without, with an exemption from the Department of Labor. So the next slide, there are basically, I would call them two types of exemptions. There is the statutory exemptions. Those are passed by Congress, and they can be found in 408B and in 4975D. And those, again, as I said earlier, anybody can rely on them at any time without notifying the department of that reliance. The other types of exemptions are class exemptions. As Steve mentioned, I did help write the class exemption for cross-trading involving model and index funds. There's quite a few out there, and it might be that as the class exemptions have come out, that has lowered the need for individual exemptions. Again, if you comply with the class exemption, you're good to go. You don't have to talk to the Department of Labor. And then there are the administrative exemptions, the individual exemptions. And that's really what we're focused on today. And that's really what the new rules that the department has put out relate to, is how to apply for an individual exemption. The next slide, please, number 11. Or excuse me, they're there, number 10. You're right. You were right. Sorry about that. The effect of an administrative exemption, if you get your exemption, if you get the one that you're asking for, it lifts the bars created by the prohibited transaction provisions actually specified in the exemption. So when you ask for relief, you need to make sure you're asking for relief from every PT provision, prohibited transaction provision, that you want relief from. And that's very important, because you cannot rely on it for relief from other non-specified prohibited transaction provisions. The exemption might be affected for a limited amount of time. And like I mentioned, some of the more recent applications for exemptions relate to relief from QPAM, for QPAM relief related to convictions. And the department has issued some that only cover 5 years, 4 years, 3 years. So you need to be aware of what relief, if it's going to be for a limited amount of time. And it's limited to the specified parties in the exemption itself. If you're specified there, great. If you're not specified in an individual exemption, you cannot rely on it. The compliance with the exemption does not relieve a fiduciary from other provisions of ERISA. I would note that 408A specifies it only provides relief from the provisions of 406 and 407 of ERISA. It doesn't provide relief from anything else. So you could have an exempt transaction that's otherwise looks clean, but if it's not in the interest of the participants and beneficiaries, if there's something disloyal, whatever, the exemption will not clear you of that. And I would know.
Can I ask a question? Maybe I'm sure you're going to bring it up later. Maybe I'll ask it now. So in terms of applying for an exemption on a PT, there's always the overlay of the background. Like you say, on the one hand, that the fiduciary is not relieved from general fiduciary responsibilities. What is your take on the requirement to talk about, at least to build into the application process, the fact whether it is prudent or not? Is that a strategic thing to do? Do you want to make those statements, even though technically you're looking at the PT standard, you're looking at the PT itself, not necessarily fiduciary? And what about the related issue of considering and weighing alternatives? Like oftentimes when we're involved with the PT application, or if we're the fiduciary, we're writing we're the independent fiduciary doing the report as part of an application, we talk about, we address alternatives. By the way, we also considered a lease, or we looked at a different piece of property, or we considered, building our own rather than buying one, like in the real estate context. What is your thought on that generally?
Let me ask you the next slide, because I think that'll address the first part of your question, which is number 11. Go back one slide, please.
Yep.
One of the things you do have to convince the department of when you are asking for an exemption is it in the interest of the plan and its participants and beneficiaries? And so is it prudent? Yes. So you do have to have that in mind when you are making the application to the Department of Labor. Is it protective of the rights? Is it, and really, is it prudent and loyal if you want to read into those two provisions? So you will need to address it. It'll be an unlikely situation where you go through the process and then somebody turns around and says, well, this was imprudent or this was disloyal. The process is pretty good at highlighting those types of issues. Even so, it's important to keep these rules in mind. And it involves as a practical world. Again, I'll go back to cross trading, where you can do cross trading in ways that are otherwise compliant with the statutory provision or with the class exemption. But if you do it in a way that is still imprudent or disloyal, the exemption won't clear you of that. And I've got, from my experience, some sort of practical history with that. As to the other part, when you're looking at the alternatives, the department will, and we'll talk about that in a little bit, will ask, well, did you look at other transactions? Did you look at other ways of doing this transaction that didn't involve a PT? And you will need to go through that. And as I'll get to it later, there was back and forth between the department and commenters on it. It was a hot issue. How far did you have to go in looking at alternative transactions? Did you have to sort of survey the universe of possible alternatives? And the answer to that is no. You really just have to describe what sort of due diligence did you do? Did you engage in a prudent process in determining that there was no other practical alternatives that did not involve a prohibited transaction to get your client to where they wanted to go, to get the applicant to where they wanted to go? So that is part of the process, and we'll touch on that later. That's a good question. I would note that these are the three rules there. I just took straight out of 408, pretty much. 408A of ERISA. That's what the department is focused on when it's doing its job. The Department of Labor has asserted that when it issues an administrative exemption, it does so at its sole discretion. Whether or not there are limits to that discretion, whether or not one could force the department, I don't know. I don't think I've seen that tested in the past. But the department has put a marker down in the new procedures saying it is doing it at its sole discretion. Next one, the amended definition. So this, we're going to start touching on here on what is new. What is new with the new rules? And I will, just as a warning, the new rules are long, they're detailed, they are complex. The hope by the department, and they say it in their preamble, was to enhance the efficiency, clarity, and transparency of the process by basically taking everything that they say that they've required in the past, informally, in the context of prior transaction reviews, and they're said, this is what we do, this is what we're looking at. There should be no mystery here. And they're trying to make it as open as possible and as transparent. That will go to some of the things I talk about. They're going to make the record public. Everything in the record public will go to that as well. But that is their hope here. So some of the things that they've done in a clarifying and hopefully making this more reflective of what they've actually been doing informally is they've amended the definition of an affiliate of persons to be broader in many ways. It covers any of these persons, and I'm not going to read this to you, you can read it there, but it really is designed to, when you're looking at, well, who's being affected by an exemption transaction, they want the broadest universe possible of affiliates and affected persons, and they've changed that definition. You'll have to know who these people are and to the extent that they are being impacted by the proposed transaction exemption. The next slide, please. Qualified independent appraiser, again, very detailed. I won't go into all the details. Some of the requirements, obviously, the first one, the entity needs to have appropriate professional qualifications, and an application will have to have, sort of how the independent fiduciary selecting the appraiser or the advisor, whether it's a consultant, an accountant, an actuary, et cetera, how they have the proper qualifications. That's in there. And the entity needs to be independent. And this is really a focus of the department all across this new exemption routine, their new regulation, is they want to make it clear that they're looking for an independent advisor who is independent of the parties involved. And again, go back to the affiliates of the persons, the broadest universe of those individuals. So they look at the facts and circumstances, and the application will need to include those facts and circumstances about their independence, how they were selected in terms of a lot of different things. One of them they're focused on is the influence of the counterparty to the transaction in selecting the appraiser or the other expert. If the counterparty is very involved, that will be a red flag for the Department of Labor. The other thing the department really looks at are the fees. The fees that the appraiser will earn in a year, and I said this year, but it's really in a year, from the parties and interests and affiliates to the transaction as a percentage of all their fees earned last year. And there's a 2-5 rule that they've articulated in these new rules. Basically, the 2-5 rule is that if you're under 2% of the annual fees coming from parties and interest related to the transaction, you'll probably be okay. Not necessarily, the department has not foreclosed its review of under 2%, but it's letting you know that you're probably okay. Between 2% and 5%, they use the term heightened scrutiny, that they'll look at that. They're going to wonder, well, that seems to be a bit of money now coming in from these parties. That could influence the independence of the appraiser. We're going to look at that closely. And if it's over 5%, the department is signaling that is going to be a red flag. Again, they're not foreclosing that might not be acceptable, but they are letting the public know if over 5%, you're going to have to explain carefully why you still thought that the independence of this appraiser is not going to be impacted by in its review of this particular exemption transaction. Let's go to the next slide on the qualified and independent fiduciary. It's similar to what they did with the appraiser. They're going to want a demonstration that the entity has the appropriate professional qualifications to do the job. Experience counts. It is not a disqualifying thing if the entity has experience in this area and expects to continue to work in this area. That's okay. But again, that will go to the independence in the terms of this applicant and this exemption transaction for which the application has been filed. They're going to look at the facts and circumstances about how, about the independence. They're going to want to look at the influence of the counterparty in selecting the fiduciary. And again, they're going to want to look at sort of this 2-5 rule, as I described before. Under 2, probably okay. Under 5, between 2 and 5, heightened scrutiny. Over 5, red flag. So those are kind of the new changes, or at least the clarifications, I would say, to the new process. The next slide.
Hey, can I just ask a quick question,
Sure.
Mike, before we go on to this slide? So I know there were a lot of comments on the definition of qualified independent appraiser and fiduciary.
Mm-hmm.
One of the concerns was that smaller people just might get squeezed out of the market. If you're a smaller firm and you're as independent as the day is bright with sunshine. I mean, you're independent, but the scope of your business is such that, or maybe you're a startup. It's your first year, you broke away from a big firm, you're starting your own firm, and the way they measure it, in the first year, you took on an independent fiduciary or an independent appraiser project, qualified independent appraiser or qualified independent fiduciary project, and you're over those, it's just concentration risk. You're over the limit. So it seems to disfavor maybe smaller, entities or newer entities. I'm just curious on your thoughts about that, and also kind of the related issue of your business experience. I recall that language that where the department says, excuse me, that they want to know, one of the factors they'll look at is whether this fiduciary has an interest in the subject transaction or future transactions of the same type. So if you're in the business of being an independent fiduciary, you're in the business of being an appraiser, and you think you're good at it, and you want to let these ERISA governed situations know that you're available, you will take on the risk, you could potentially be tainted by your own expertise because you've done a lot of them and you think you're good at it and you want the world to know about it. How do people address that?
So those are all important factors that I think the department will look at, and the department has made it clear it's going to look at those factors. And it hasn't foreclosed anybody under, again, it hasn't set bright line rules. If you're over a certain amount, you're out. Or if this is your business, forget it, walk away, because we don't think you're going to be able to be independent if you're just doing another transaction that is your bread and butter. But those will be factors that the department will look at, and you will want to address for the small entity. To the extent that the department does seem to be very focused on revenue stream as an indicator of independence or lack thereof, you're going to want to think long and hard about bringing in a small entity, a new entity. It does, unfortunately, place a damper on those types of entities. There are arguments that can be made for anybody and to the department, and it will be, and if those arguments are made, they will be part of the record, and the department will disclose it to the public, and maybe that will help in getting otherwise questionable, or not, and questionable is not the right word, but people who do have these issues that need to be addressed, and entities with these issues move forward as part of an application process. But to the extent that that goes to independence, the department has made it clear it wants to look at all of those factors.
Yeah, I would hope the extent that that you have familiarity of, you're in the business of being a fiduciary, you certainly have experience with a number of transactions, that your experience as a qualified fiduciary understands the nuances and requirements of the law, the terms and conditions of the application, understands ERISA, what it really means to be a fiduciary, that your experience of doing a good job would outweigh any taint of being, a self-promoter to the point that you're losing your independence. One would think that argument would have some legs anyway.
And I think that's right. I think it should. And the larger the entity, the less likely that the revenue stream is going to be a factor. Experience does count. The department has, it's the first requirement there are the qualifications, and experience is part of those qualifications. The fact that an entity has engaged in these types of transactions in the past, has done so without hiccups, without controversy, that counts for a bit. That does give confidence that the entity does know what it's doing and is prepared to step up and do the right thing in any future transaction. So, but it'll be disclosed, it'll be in the record, and the department will look at that. And that record, again, I wanted to sort of touch on the pre-submission applicant, the entity that contacts the Department of Labor ahead of time, orally or in writing, and that could be anything. And when I was at the department, I was there for 30 years. And I also did write the exemption for cross-trading. And I would get questions all over the place over cross-trading and the like, whether I was just picking up the phone and answering a call, or I was speaking at an event. And people would ask questions all the time about different things. And I was encouraged to engage with the public. So whether or not this puts a damper on those types of informal discussions, I'll be curious in seeing. But if you do engage in a pre-submission discussion with anybody at the department on this, solicitor's office, EBSA, or I guess anywhere else at the department, keep a record of it. because you will be expected to include any specific discussion related to the exemption transaction as part of the public record, as part of your application. There are limits. I mean, theoretical questions about non-specific transactions, I think you would be okay. But more specific discussions, keep a record of it. And of course, at least the beginning, err on the side of inclusiveness, not otherwise. Those will go into the public record. Next slide.
And by the way, audience, I think we may have failed to mention at the beginning, but if you have any questions, hit your Q&A little toggle on the format, and we'll try to respond. If we don't have time for it during this session, Mike and I will email back to you. We'll get back to you with some help to your questions if you have any. So sorry, Michael.
Absolutely. Oh, no problem. Absolutely. Another change, they made clear certain things that they do not want to see in agreements. Agreements with independent fiduciaries, professionals may not have direct or indirect indemnification. And that was a huge controversy, but the department stuck with its guns on that one. They are allowing for the reimbursement of certain legal expenses, but only if an independent fiduciary for the plan determines that reimbursement is prudent and determines that the professional did not fail to adhere to the contractual or legal obligations. So that will require independent fiduciaries review before reimbursement. And the professional agrees to repay the amounts if there's a settlement thereafter or there was a finding of a breach. So whether or not that discourages settlements of claims will remain to be seen. I would note that even if the reimbursement is paid for by a party other than the plan, these requirements still apply. So you would still have to have an independent fiduciary determining that the reimbursement was appropriate. I would note, of course, that no agreement can have a provision that would violate Section 410 of ERISA. That is the section that says no agreement can relieve a fiduciary of responsibility or liability for a violation of Title I of ERISA.
Michael, can legal fees be advanced, or is it only reimbursable?
Well, they must be advanced to the extent that before a matter is resolved, because otherwise this provision about settlements or a finding by the court makes no sense. So I assume that they can be, as they are incurred during the course of the controversy, a bill is then submitted to whoever and reimbursement happens at that point. But as written, it would seem to imply that you can, of course, reimburse the legal expenses while the controversy is continuing. Okay, the next slide, 17. Agreements with fiduciaries, they're similar. We don't have to touch on that, but just so it's clear. Next slide. Whoops. New issues regarding appraisers and other consultants, and the application needs to have a representation by an independent fiduciary that it prudently selected the appraiser after diligent review. And an independent fiduciary does not necessarily mean an independent fiduciary hired for the transaction. It could be a fiduciary for a plan. The independent fiduciary represents that the appraiser is independent and that it's technically qualified. So again, going back to the requirements that I discussed earlier, the department wants to see that somebody has already, on behalf of the plan, done that review before the application is filed. Next slide. There is, excuse me, more information that must be included. That if there's an independent fiduciary selected, there must be a representation by another fiduciary that it was selected with care, independence, and qualified. Again, touching on the same things. There must be a statement that an independent fiduciary has not been under investigation and by specified entities or convicted of a crime, and very, very detailed disclosures about anything. If the independent fiduciary has been involved in any kind of tangle with the government, with few exceptions, or with any type of litigation, that will need to be disclosed. Next page, 20.
I just want to reinforce here something. This is a great example, looking at all these terms and conditions, something that you said earlier, Michael, which is that the department's view in finalizing this regulation was that it is simply it's to make our job easier. These are the questions that it has always asked, the requirements that is imposed anyway, and by making sure that everyone totally understands up front all these different things that need to be done, all these conditions that need to be satisfied, it'll facilitate a more efficient review and a quicker process, and is meant to encourage people just to be prepared when you apply for an exemption, and to have all the information at hand, rather than the ping pong back and forth over months and years, to pull all the information out.
Right, and just a little history in terms of, if I mentioned earlier that a lot of the exemptions that were filed last year related to entities that were seeking relief under the QPAN exemption because they'd been convicted of crimes, foreign, domestic, or otherwise. And the department, unfortunately, has had to have a lot of experience with this issue. A while back, when they proposed to issue an exemption for some entity I won't name here, they were actually called out by members of Congress questioning whether or not it was appropriate to continue an exemption in light of a foreign or domestic conviction. And so the department, for its, given its history, wants to be really careful that when it does approve an entity for an exemption transaction, that it doesn't get blindsided by some other action as it had in the past. So I think that's these detailed requirements reflects the experience of the department over the years. Application requirements for individual exemptions. There's two sections, 2570.34, which applies to all exemptions, and then there's 2570.35, which applies to individual exemptions. 2570.35 is a bit repetitive of some of the things previously, so I apologize now if the slides are repetitive, but just so you understand, it reflects the new procedures as the department has issued it. Again, confidential information, I wanted to include that here, will not be accepted by the department. It will not keep anything secret. If you do try to submit some confidential information, trade secret information, financial secret information, the department will probably not proceed. It is saying it will not proceed with the exemption request, except if you're talking about a government entity, which is unlikely to be your case. The department wants to make the entire administrative record public. It's going to do that, and it's made that clear. Next slide, please. Again, this is for the individual exemption. It's not an exhaustive list on the slides. It is an exhaustive list in the new regulations. All sorts of things, from the identity of the parties involved to a chronology of the events leading up to the exemption transaction, reasons for the transaction, the material benefit that a party in interest or affiliate, again, the broader group, might receive as part of this transaction. So don't just look at the prohibited transaction provisions and the parties in interest there. You need to think wider to related parties to those parties in interest, the costs of the benefits of the transaction to the plan. And again, as Steve mentioned earlier, the alternatives that did not involve a PT and why they were not pursued. Again, they don't want a hypothetical from every possible transaction under the universe. Just what did you do in the reasonable world to make sure that there weren't reasonable alternatives available? Next slide. There's a description. You need to include a description of each conflict of interest or potential self-dealing that would be permitted if the exemption is granted. Again, this is shorthand, whether the transaction has been the subject of an investigation or enforcement action. Likely, if it's part of a government DOL investigation or enforcement action, I talk to us before you make such an application. That's likely not to go over well. Hardship or loss that would occur if participants and beneficiaries, if the exemption was denied. And again, in the most recent exemption applications where these Blue Cross entities had a failed investment, that was a big factor, I think, in the department's approval of those transactions. Because if Blue Cross, the entities, weren't allowed to make those contributions, the plans might have had some funding issues. So that's a big deal. Next slide. A description of how the exemption meets each part of 408A, administrative feasible, in the interests of the affected persons, protective of the rights, the stuff I talked about earlier. And then it's a new item, a statement that the exemption is in the best interest of the plan, compensation received is reasonable, and that none of the statements DOL are materially misleading with made, or why any of those three standards are not applicable. I would suggest that the one that they're really focused on is the best interest exemption. There was back and forth about the department's desire to have sort of a best interest provision, included in the regulation. There was pushback on that, and so the department has given an out. Honestly, if the fees, the compensation is unreasonable, or any of the statements are not materially misleading, I don't think the department's going to excuse that. You can make the discussion, but honestly, I think the department's really focused on this best interest and on the types of the arguments that commentators were making as to why that might not be appropriate in certain circumstances. All right, next slide. Declaration. I'm moving a little quickly because I see we're coming up on about 10 minutes. Declarations are no longer under penalty of perjury. That didn't seem to be controversial. Must include statements and documents by the appraiser supporting and other professionals supporting the application. That's not new. The reports, valuations, appraisals need to be current and not more than 1 year old from the date of the transaction. So that's important to keep in mind. It could be 1 year from the date of the application, but the department is looking for 1 year from the date of the actual transaction. A description of the relationships between any party in interest and professionals, including a description of the past engagements, which really should have been disclosed under some of the earlier areas that I described. Then there's new specific disclosures by appraisers, new specific disclosures by independent fiduciaries. I do not want to go into them now, but they're just listed. It's like a menu. You just go through it, and you should be good to go. Next slide. Additional information required for individual exemption requests. Just make sure you touch on that list. Don't think that the one rule under section 34 completes section 35. It's a little different. Information identifying the plan and plan sponsor, that's obvious. Prior investigations, enforcement, again, detailed requirements about any past run-in with the law or the like. So again, this is a good summary, but there are detailed requirements you should be aware of. Next slide. Prior current investigations, again, more detail there. I want to make it clear just so you see the breadth. And as I look at this, I can tell you DOL has experience with these types of things, and really wants to make sure it doesn't have to deal with this type of issue going forward, is my understanding. Next slide. More requirements, again, identifying, this is again in the individual, which is sort of a copy of the prior one, but I want to focus on discussion of who will bear the costs related to transaction, any prior transactions involving the plan. There are special rules for exemptions involving pooled plans. It is depending upon the interests of the plan involved and or the plans involved in the property and the nature of the pool. you're going to want to really look closely at these rules and make sure that you understand exactly what the department is looking for, given the nature of the transaction, the pool, and the plan, and the like, and who exactly the exemption transaction is being done with. Next slide. Retroactive exemption requirements. There's a new section there that discusses the rules for that. I think the department wants to take the lid off that as well. Your only recourse if you've done a transaction in the past isn't necessarily to pay fines and other things, but you can seek a retroactive exemption. The department is going to want to know what safeguards were in place at the time of the violative transaction, wants to know whether plan participants were harmed or not when the transaction occurred, want to know that, you know, the fiduciaries and the plans were acting in good faith before the transaction, and then at the time that transaction occurred to protect the plan from abuse, loss, and risk. And then a discussion about whether the transaction could have been performed without an exemption at that time. I should note, anything that comes to the department in an exemption application does not provide immunity. When you do disclose an exemption transaction to the department, to the Office of Exemption Determinations, they could easily shift it over to the Office of Enforcement, which is where I was, for enforcement. They might say, you know what, we can't bless this, and indeed we think the Department of Labor needs to look at this for enforcement action. So you should keep that in mind. Next slide. Just a shorthand list of the factors the department says it will consider: the independence of the fiduciary at the time the transaction occurs and how they were involved, whether there was an extemporaneous appraisal or a reference to a third-party source, such as publicly traded stock or related transactions, appraisals, the like, demonstrating that the price was right at that time. Evidence that there was a bidding process or a prudent process, that the plan was actually doing it correctly when it was doing the transaction. It was engaged in a prudent process with unrelated parties, etc. Evidence that the fiduciaries should not have known that transaction was a PT, which is interesting because under Title I of ERISA, the 406 rule is, did the plan know or should it have known? Did the fiduciary know or should it have known? But under Title II, there is no scienter requirement. If there is a transaction involving disqualified party, scienter is not a requirement to the imposition of the excise tax. And so while there may or may not be Title I liability, you're still going to want to get an exemption to avoid Title II liability. Statement of the circumstances upon discovery of the violation. You know, what did you do when you found out? How were you, again, acting to protect the plan? And a confirmation that the transaction was as favorable to the plan as that in a similar transaction with an unrelated party, i.e., yeah, we did a PT, yeah, it was technically a violation, but this was really just, it was a good transaction for the plan. Even if they'd done it with an unrelated party, it would be okay. This is not a complete list, but it is the kind of things that the department is looking for. 30 additional rules. There is a duty to amend your application if you discover new information. There is a duty to call the Department of Labor if there is some legal entanglement that arises. Department of Labor could issue a denial letter, a tentative denial letter, or even a final denial without issuing a tentative denial. At that point, you do have a right to request reconsideration. You only have a right as an applicant to run conference with the DOL, but you can request more. And if you do have a conference, you have 20 days thereafter to submit additional information. Of note, the DOL is reserving the right to meet with any other party, including the appraiser or the independent fiduciary, with or without the applicant in the room. The department might say, you know what, we want to meet the appraiser by themselves without any other party. And they've put a marker down that they will do that. Next slide. Notice to interested persons. The applicant, if you are applying, there will be a proposal. It will go in the Federal Register. Then the applicant is required to provide a copy of that notice and any supplemental statement to interested parties and certified back to the department, to the interested persons, certified back to the department that it's done so. Who is an interested person is a facts and circumstances. Usually it's participants and other parties involved with the plan. Next slide, hearings with the department, including, in addition to the hearings I talked about earlier, the conference I talked about earlier, anybody can ask for a hearing with the department, particularly where there's a case of self-dealing. The department is interested in having hearings with anybody materially affected where they have factual information or want to explore material factual issues. They're inviting anybody to apply for a hearing with the department in that situation. Again, the same notice requirements at the applicant's expense apply. And that's where I'm going to stop. The rest of the slides talk about the expro process. I would note that the department has not, in its new regulations, done away with the expro process, which is an expedited mechanism for an application where you're just asking for the same relief that somebody else has asked for an individual exemption in the past, and you think, you know, you really qualify on all fours with the same requirements and the same circumstances surrounding the exemption. There's a way to get that expedited. The department hasn't closed the door on that. I would note there really hasn't been an expro application filed in the department in the last 4 years or 3 years. Whether or not this encourages people to engage in expro or not, I suspect not, but I'd be happy to be proven wrong. So that's really it. That's all I have. Steve,
Michael, I have a question. Thanks for walking us through that. That was fantastic. Two questions. Number one, you know, I'm thinking of like just our own, you know, recent experiences over the last year or two on what we would think are, you know, fairly standard real estate transactions, but because of the tightening and positioning of the department vis-a-vis indemnity.
Mm-hmm.
We've had a certain number of appraisals that say, well, our standard engagement letter, we just want indemnification. We won't do it without it. Or we have a standard, you know, loss limitation on our appraisal. So there are some appraisers out there that we have found, good ones, reputable, competent, you know, that we think are qualified, that are willing to go without that language. Others require that kind of support in the contract. I suppose the answer or the workaround for, you know, an appraiser that doesn't like the terms and conditions of its own engagement letter vis-a-vis DOL requirements would be to say, maybe you just have to charge an increased risk premium as part of your fee for, you know, in lieu of the indemnification language or loss limitation language that you otherwise would have liked. It just seems like, you know, I think there's some pressure on the market, you know, in terms of the number of service providers that are out there. Just an experience that we've had. I don't know if you've seen that before or have any thoughts about it. But it's definitely tightened as far as we can tell, it's tightened the appraisal market a little bit, you know, I think that concern was in some of their comment letters as well.
Yeah, no, that is a concern that the department hears about in this context and in a whole host of contexts. And the department is constantly trying to seek a balance between doing what it sees as its job of protecting participants and beneficiaries from harm, which does have a cost. And all of this has a cost, whether it's the indemnification provisions. The department also, I didn't talk about it because of time, but there's the fiduciary insurance requirements. You will need to include a discussion about the insurance. The department has made it clear that it would like to see insurance that's sufficient to cover all of the possible losses that could be involved in a transaction. Well, that will, in some transaction, will have a huge cost, maybe insurmountable. But the department is trying to protect participants to the best that it can, and wants to see a discussion in the application that the fiduciaries consider that as well. There will be a balance, and in certain facts and circumstances, there might be arguments that can be made to the department saying, look, the chance of loss is so small because of the particular nature of the transaction, that the idea that, maybe you're talking about property, no, it's not going to sink under the San Andreas Fault. It's in Missouri. Don't worry about it. We don't have to cover the full cost of the property, just the amount of possible loss and the flow of market trends. I don't know what specific arguments could be made. The department hasn't foreclosed any particular argument, but it has said that it will accept increased costs if that is necessary in order to protect participants.
Final question, and we're coming up on the hour too. So I know that this regulation by definition applies to the application process, but there are some terms of art in there and some concepts, definitions of a qualified independent fiduciary, definitions of a qualified independent appraiser, what goes into a qualified independent appraiser's report. For situations where, for ERISA-centric transactions where fiduciary principle, fiduciary concerns are present and people are presenting themselves as an appropriate and prudent appraiser, fiduciary, and all the other things that we learn from this reg. Will these definitions and terms and conditions apply in the non-PTE application context? Should we assume the department will just carry these over, these concepts and these definitions and these requirements, even if technically you're not dealing with an application? Or is there some other, is there some tolerance or room for variation because you're technically outside of the scope of the regulation?
Well, so outside of the scope, I would suggest that there might be a lot of contexts where these rules might come into play by people seeking to make analogies, whether it's in litigation. I can see, if you're litigating the independence of a fiduciary or litigating the independence of an independent appraiser, you might say, hey, this is an interesting checklist. I'm going to depose the other side based on this. So I can see an application of these definitions in the broader community, to the extent that, your first question went back to sort of prudence and loyalty and how is the department looking at those issues? And my view was, well, yeah, under 408A, the department kind of has to look at those issues. And so could somebody argue based on analogy in other contexts that these definitions should be looked at, should be applied in some way? I absolutely think so.
Okay, thanks. No, I agree. I think they're great benchmarking and really will be helpful. And as we said earlier, this is where we are. Yeah. Some people like these terms and conditions and definitions, others don't. This is where we are. So I think that, to the extent that we're advocates as attorneys, or we're consulting, or we're serving as fiduciaries, we just have to learn how to use these rules ultimately in the best interest of plan participants and beneficiaries. If that's your compass, that's a great direction to be heading, as long as you're heading that way. That's what really matters at the end of the day. So we're on the hour. Thank you, everyone, for attending. It was a pleasure. Please let Michael or I know if you have any follow-up questions or concerns, and we'll check our Q&A screen here. If you've typed any in, we'll get back to you as well. So thank you for your time, and on behalf of the Wagner Law Group, hope you have a great day. Thank you so much. Thank you, Mike. That was terrific.
Thank you. This was fun.